and myself. So good afternoon, everyone who's just joining us now for the exact time to start the webinar. My name is Mona Forrest, and on behalf of the Canadian Cancer Survivor Network, I'd like to welcome you to today's webinar. This webinar will focus on the recent Canadian federal court decision on medical marijuana, when Judge Michael Phelan struck down federal regulations which prevented medical marijuana patients from growing their own marijuana. Our host today is Trina Fraser of Ottawa business law firm Brazo Seller LLP. Trina's business law practice includes advising marijuana for medical purposes regulations, industry participants on regulatory issues. The topics going to be covered today in today's webinar will include an overview of the court case, including the main details, the plaintiffs, and what they were seeking, analysis of the evidence presented during the proceedings, what the decision means for patients and producers, and what's to come for medical marijuana in Canada following this decision. After the presentation, you'll have the opportunity to ask questions during an interactive Q&A session. There's a little box down on the right, and you can type your question in there anytime, and Trina will start answering questions just right as she's finishing her presentation. For those of you who haven't attended an earlier webinar, this webinar is hosted by us, the Canadian Cancer Survivor Network. At CCSN, we work with patients, survivors, families, partner groups, and sponsors on collaborative action to identify and remove barriers to optional patient care. We ensure access to education and action opportunities and survivor involvement in healthcare decision-making. That's an important one. We also support evidence-based research on ways to promote equal access to early diagnosis, timely treatment, and follow-up care. If you'd like to learn more about CCSN, you can visit us on our website, which is www.survivornet.ca. And right now on our front page, you can read about the association between cancer and thrombosis. Thrombosis is the second leading cause of death in cancer patients after cancer itself. You can read about our meeting with Ontario Progressive Conservative health critic Jeff Urich, and you can read about many different opportunities to get involved or to volunteer with us. Now, over to you, Trina.
Thanks, Mona. I'm happy to be here today speaking to all of you about the Allard decision. I know the title of the presentation is What's Next, but as Mona indicated, I think in order to have that conversation, we first need to review the case, understand what it was about, how the decision was rendered, and then put that as the use that as the context for talking about what we can expect to see going forward. Okay, so it was more than a 100-page decision, so I guess that explains why it took Justice Phelan so long to write it. It's quite a bit to digest, but we've had a bit of time now to go through it. What is the case about? So basically, there are 4 plaintiffs in this case, and the plaintiffs were taking issue with the government's decision to transition from the marijuana medical access regulations, which I'll refer to as the MMARs, to the marijuana for medical purposes regulations, or the MMPR. And really what it boiled down to was the plaintiffs took issue with the elimination of personal cultivation licenses, which existed under the MMAR and do not exist under the MMPR. As you all probably know, under the MMPR, access to medical cannabis is now exclusively via licensed producers. So, I should also maybe just quickly refresh everyone's memory. The MMARs came out of a court decision in the Ontario Court of Appeal in 2000, the Parker case, which, constitutionally mandated access to medical cannabis for patients. The MMAR went through a number of court challenges over the years and were amended a number of times to comply with court rulings, and ultimately the government decided to move away from that type of a model completely and move to this concept of commercial production. So who are the plaintiffs in this case? As I said, there's 4 of them. There was Mr. Allard, who's a 60-year-old man suffering from chronic fatigue syndrome. He produced his own cannabis and had a prescription for 20 grams per day. Mr. Davey, a 38-year-old man suffering brain injury, brain injuries from a motor vehicle accident, also produced his own medical cannabis and had a prescription, has a prescription for 25 grams per day. And Ms. Beamish, a 27-year-old woman with type 1 diabetes and complications therefrom, had an authorization to possess cannabis with a prescription of 5 grams per day, and her common law spouse, Mr. Hebert, is a 31-year-old man who possesses a designated person production license to grow for her. So 3 of the 4 plaintiffs were actually cannabis patients, with the 4th one being the designated grower for Miss Beamish. Okay. What were the plaintiffs actually seeking in this case? Well, what they were looking for was initially an exemption, primarily an exemption from the relevant provisions of the Controlled Drugs and Substances Act. So really that's sections 4, 5, and 7 of that act, and those are the offenses for producing, possessing, and trafficking narcotics. So ideally what the plaintiffs were seeking was a complete exemption from those sections in respect of their production and use of medical cannabis. They also sought, in the alternative, to just go back to the old MMPR program, and kind of coupled with that, you saw them seeking a strike down of the MMPR, or at least in the alternative certain aspects of the MMPR, specifically the restrictions to dried marijuana, the restrictions on possession, the restrictions on indoor growing, and so certain specific aspects of the MMPR. Actually, I'm just going to skip back to my slide about the plaintiffs for 1 second. It's interesting to note that all 3 of the plaintiffs who were cannabis patients had higher than average authorized amounts under the MMPR or under the MMAR. So if you see 20 grams a day, 25 grams a day, even 5 grams a day, the average medical document amount prescribed per day under the MMPR over the period of April to September last year was 3.2 grams per day. So it's relevant in this case because the fact that these plaintiffs are all higher than average users of cannabis, and that's for a variety of reasons, including the fact that they'd built up a tolerance over a period of time, and I believe they did extractions, which requires a larger amount of dried cannabis. But this meant it actually played into the issues of affordability in particular, and also assurance of supply. So the plaintiffs were alleging that the new MMPR system, and in particular the elimination of personal cultivation rights, violated their Section 7 charter rights. So just to refresh your memory, Section 7 of the Charter says that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Now, what specifically were they complaining of? Well, they were saying the problems specifically with the MMPR were access, affordability, and availability. So they couldn't afford it. They had no assurance of the supply of the strain of their choice or strains of their choice, and they just simply wanted control over their own health care and frankly found therapeutic benefits from cultivation. So when the court's faced with a Section 7 charter challenge, they basically are engaged in a 3-part test or analysis. And the first part of that test, the first question that the court asked was, were the plaintiffs' Section 7 rights engaged by the restrictions in the MMPR that they were disputing the constitutionality of? And the court answered that yes, these rights were engaged. The right to liberty was engaged in 2 ways. First, their right not to have their physical liberty endangered by the risk of imprisonment, and that's specifically the risk of imprisonment if they were forced to obtain their medical cannabis illegally and outside of the MMPR, either because they couldn't afford it or they couldn't obtain their strain of preference from a licensed producer, or if they exceeded the 150 gram possession limit cap that's in the MMPR. Just to take you back, under the MMAR, license holders were authorized to possess up to a 30-day supply of their cannabis. But if you kind of do the math with Mr. Davey, for example, having a prescription for 25 grams a day, a 150-gram cap means he's only able to possess at any one time a 6-day supply of his medicine. And the second way the liberty interest was engaged was the right to make decisions of fundamental personal importance. And the court found that being able to direct your own medical treatment is a decision of fundamental personal importance. The court also found that the plaintiff's security interests were engaged because if you cannot access an LP for the reasons you know, I've already set out, then you don't have legal access to your medication, this can result in physical or psychological suffering. So the answer basically to the first question was yes, Section 7 rights there is a prima facie infringement of Section 7 rights. I'm just going to flip back to the Charter page again, and if you look back at Section 7, it says everyone has the right not to be deprived of these rights except in accordance with the principles of fundamental justice. So part 2 of the analysis that the court engaged in then was, are these restrictions on access that we find in the MMPR in accordance with the principles of fundamental justice? And the court, you know, answered no to that question. To engage in this analysis, the court considered what are the objectives of the MMPR? What is the government trying to achieve through this regulation? And the court found that there are 2 objectives to the MMPR. The first was the reduction of the risk to public health and safety, specifically with respect to personal cultivation. So that was obviously the cornerstone of the government's case, was that the removal of personal cultivation rights was as a result of the inherent risks involved in personal cultivation. And then the second objective of the MMPR was improved access to medical cannabis. So the court really engaged in an analysis of both of those objectives and tried to determine if they were connected to the restrictions that exist in the MMPR. With respect to the risk to public health and safety, as I said, the government's case was really founded upon allegations that there were a number of risks to public health and safety inherent with personal cultivation, and those risks included the risk of fire due to electrical issues, the risk of mold due to excess humidity, the risks of theft and diversion, and theft and violence, and then finally the risk of diversion to the black market. But ultimately, the court didn't buy that argument and found that there was no rational connection between the prohibition on personal cultivation in the MMPR and actually advancing and reducing any risk to public health and safety. And frankly, it was mostly because they just found that those risks the court just didn't buy that those risks actually even existed, or if they, to whatever extent they did exist, they were manageable. On the improved access objective, the court found that access was not improved through the MMPR, and in fact access to medical cannabis was actually further restricted, so it actually went the wrong way completely. Therefore, the court found the MMPR is arbitrary and overbroad, and that leads to a finding it's contrary to the principles of fundamental justice. So there you've got now the court finding there is a Section 7 violation here, but whenever we have a charter violation, you still have to go back and see and determine if that violation can be, that law can be saved by Section 1 of the charter. Let's just skip back to that slide one more time. Section 1 of the charter says that your charter rights are guaranteed only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So that's the third part of the test that the court then considered was, can these restrictions be saved, can this infringement be saved by Section 1? Is it demonstrably justified in a free and democratic society? The answer ultimately was no, it's not saved by Section 1. So the court found that the plaintiffs had demonstrated that cannabis can be produced safely and securely with limited risk to public safety. The court didn't buy into the government's position that a complete prohibition on personal cultivation was warranted in order to protect public health and safety. So, the court said, look, fire risk can be addressed by simply complying with electrical safety requirements. The mold risk can be mitigated with proper ventilation systems. Theft and violence can be addressed with security. And the risk of diversion admittedly exists, but it exists with licensed producers under the MMPR just as it does with cultivators under the MMAR. Frankly, I don't agree that the same degree of risk of diversion exists, knowing what the security requirements and the seed to sale tracking requirements are that licensed producers are subject to, but nevertheless that was the finding of the court, and therefore the MMPR was declared to be invalid. It is interesting to note that the judge's findings here on constitutionality of the MMPR were really based upon an acceptance of most of the plaintiff's evidence on what those restrictions actually were, how they were not able to effectively and appropriately fulfill their medication needs through the MMPR, and a rejection of a lot of the government's evidence. The court struggled a little bit with some of the witnesses, the evidence on both sides and how much weight to be given to it, but in particular, the judge was pretty scathing of the key witness for the government, which found that he was so philosophically against marijuana, he completely lacked balance and objectivity, his assumptions and analysis were flawed, and the factual basis of his various opinions was uncovered as inaccurate. So, the government's attempts through these witnesses to prove that these real tangible risks to public health and safety existed through personal cultivation rights, the court just didn't accept that evidence at all. Now, the dried marijuana restriction, which was part of the statement of claim filed by the plaintiffs, was actually a moot point by the time the decision was, well, it is now, because I think it was after the trial had been heard, but before a decision was rendered, we got a decision from the Supreme Court of Canada in the RV Owen Smith case, where that word, the restriction to dried marijuana in the MMPR was found to be constitutionally invalid. And we have seen since that decision was rendered, in fact, we saw very quickly the government providing for the right for LPs to produce and sell cannabis oil as, I believe, an attempt to hopefully rescue their position in this case. But it's essentially not really touched on much in the decision because it has already been decided at the Supreme Court of Canada level. The maximum possession of 150 grams, well, actually the maximum possession rights under the MMPR are the greater of a 30-day supply or 150 grams. So the maximum cannot be more than 150 grams in any case, no matter what your prescription is for. So the judge actually, in this case, agreed that that cap was constitutionally sound and found that that possession cap still allows a cannabis patient to possess more than their necessary amount of marijuana, and found that as opposed to the absolute prohibition on personal cultivation, that this was an access restriction or a possession restriction that was constitutionally sound. So the court then, having found that the MMPR was constituted a violation of the plaintiff's Section 7 charter rights, had to then consider what is the appropriate remedy for us to grant in this case. The judge found it was not feasible to just strike out portions of the MMPR to achieve constitutionality. So it was not just a matter of, for example, crossing out the word dried, and so it just read marijuana instead of dried marijuana. It just wasn't going to be that easy to create a constitutionally sound MMPR. In fact, really it necessitated reading in, which the court was not prepared to do. And it also, the court wasn't willing to reinstate the MMAR, and said it's not the job of the court to create regulatory schemes. So the court also considered the plaintiff's request to just suspend the offense provisions of the Controlled Drugs and Substances Act with respect to medical cannabis, but the court wasn't prepared to go there either. So at the end of the day, the court decided that the appropriate resolution following the declaration of invalidity was to suspend the operation of that declaration of invalidity for a period of 6 months to permit the government time to enact a new or parallel medical marijuana regime. The judge also ordered that the injunction, which was put in place by Justice Manson on March 21st, 2014, is going to continue in effect until further order of the court, which essentially means until, I believe until there's a new MMPR or an amended MMPR in place which is constitutionally sound or meets the requirements of this decision. So I thought it would be beneficial just to go back and do a quick refresher about what that injunction order actually was and is. As I said, that order was put in place almost 2 years ago. Anytime you're asked, so an interim injunction basically means it's a relief that you're seeking pending trial. So it's relief that you're telling the court, we can't wait until trial to get this relief. You need to give us this relief now. Even though we haven't proven our case yet, pending a final determination of the issues at trial down the road. So it's a pretty extreme form of relief for the court to grant, and there's a pretty strict test that's imposed by the court to obtain an injunction. It's basically a 3-part test. You have to prove to the court that you have essentially a strong case, that you would suffer irreparable harm if the relief is not granted, and that the balance of convenience weighs in favor of the injunction being granted. So Justice Manson in that motion found that the plaintiffs had met that test and were entitled to injunctive relief, and ordered that certain MMAR licenses would remain in force pending trial. Justice Manson didn't agree that to the injunctive relief with respect to the MMPR cap of 150 grams of possession. So that was the one exception to the MMAR licenses remaining in force. So in other words, if you fell within the scope of the injunction, you possessed either an authorization to possess, a personal use production license, or a designated person production license, those licenses would remain in full force and effect, notwithstanding the repeal of the MMAR, except that if your possession limit was read down to a maximum of 150 grams, or possibly less, depending on what your authorization amount was. So who falls within the scope of the injunction? So it was an interesting kind of way that Justice Manson crafted the injunctive order. Basically, the plaintiffs who held a valid authorization to possess as of March 21st, 2014, which was the date of the order, and held a valid personal use production license or designated person production license as of September 30th, 2013, or got such a license after September 30th, 2013, fell within the scope of the injunction. The relevance of the September 30th, 2013 date is that was a date that was introduced into the transitional provisions of the MMAR, trying to phase out MMAR and phase in MMPR. That was basically the date at which, beyond which you could no longer apply for a new license or an amendment to your license under the MMAR. So even though this decision only technically applied to the 4 plaintiffs in the case, Health Canada decided that it would treat the injunction as applying to everyone who met its criteria, but interpreted the order as requiring both criteria to be met. So it wasn't an either or, it was both. So they put a press release up on the website soon after the decision, confirming that that all MMAR licenses would be treated as extending beyond March 31st, 2014 until a decision in the case was rendered if you met the following criteria. And you'll see they said your personal use production license or designated person production license had to also be accompanied by a valid authorization to possess as of the relevant date. And even though frankly I think it would have been pretty easy for Health Canada to check your records and the dates of your licenses and tell you if the injunction applied to you. They took the position that it was not their job to give legal advice, and if you weren't sure whether you fell within the scope of the injunction, you had to seek your own advice from a lawyer. So nobody was happy with the injunction order. The Crown appealed to the Federal Court of Appeal to try to have the injunction, the order of the injunction removed completely, and the plaintiffs cross-appealed. And the problems that the plaintiffs identified with the order was actually 2 of the 4 of them didn't even qualify for the injunction. So there was a feeling that you know, many of the MMAR licensees fell through the cracks due to the date structure and the qualifying dates that Justice Manson had included in the order. And there was also a concern that it didn't provide any ability to change addresses. So if you moved, or if the location of your production facility moved, you were out of luck. There was no ability to update your license to reflect that address change. So I think I've heard John Conroy say that he thinks about 10,000 out of the 38,000 MMAR patients actually don't qualify for the injunction, and this has been a major source of consternation ever since the order was granted. So Crown appealed, plaintiffs cross appealed, and the Crown's appeal was dismissed by the Federal Court of Appeal. They said the injunction stands, but they did find the wording of the order a little peculiar and said maybe it's worthwhile going back to Justice Manson and asking him, did he really mean to exclude 2 of the 4 plaintiffs in the scope of the order? And Justice Manson's answer was yes, I did mean to. I did intentionally limit the availability of the injunctive relief. And the reason he gave was that he intended to avoid unduly impacting the viability of the MMPR and to take into consideration the practical implications of the MMAR no longer being in force. So this, you know, was part of the pitch that was made to the court by the government, which is we've set this whole new structure in place. We've got all these licensed producers and many more applicants waiting to become licensed producers, and you're essentially taking away their market of customers, and the whole system is going to fail if you just, you know, grandfather in the MMAR carte blanche. So this was Justice Manson's attempt at restricting who qualified for the injunction and hopefully maintaining the viability of the MMPR while preserving these certain individuals' rights pending trial. So the plaintiffs weren't happy with that and launched an appeal of that reconsideration. That appeal was later abandoned, and instead the plaintiffs chose to bring a motion to vary before the trial judge, and that motion to vary was also dismissed in July last year. So all to say, the initial terms of the injunction still stand. So what does the decision mean if you are a medical cannabis patient? Well, what it doesn't mean is that you have an unfettered right to cultivate. The judge's comments throughout the decision contemplate that there would be a regulated right to personal cultivation, and that through proper regulation, the risks, any risks that did exist with personal cultivation could be mitigated. So I don't think we can expect to see carte blanche cultivation rights. We're going to see regulation surrounding it. For now, at this exact moment, there is no change. So if before the decision you fell within the scope of the injunction, you still do. If you didn't fall within the scope of the injunction, you still don't. And if you don't fall within the scope of the injunction, then your only legal source of medical cannabis at this point is to buy from a licensed producer under the MMAR. Sorry, excuse me, the MMPR. The government has until March 25th to file an appeal of the decision with the Federal Court of Appeal. If it does appeal, it will undoubtedly ask the court to stay the 6-month deadline for the declaration of invalidity, and they'll basically ask for everything to be put on hold until the Federal Court of Appeal makes a decision in the appeal. If it doesn't appeal, well then basically it's got 6 months to implement some new version of the MMPR, which you know, practically speaking, is probably going to include personal cultivation rights. I mean, I guess they could try to craft an MMPR which has such improved access to patients that, you know, personal cultivation right is not required, but I find it hard to imagine that will be what happens. Will the government appeal? I don't know. Any appeal would have to be based upon an alleged error in law, basically, or mixed fact in law by the trial judge. And because when it comes to errors of fact, a great deal of deference is given to the trial judge as being the person or the court that was in the best position to assess credibility and to make those findings of fact. And this case is heavily based upon findings of fact. So, you know, if I had to bet, I would say we won't see an appeal, but I readily admit I could be wrong, and I'm sure if the government is intent on appealing this decision, they'll find a way to draft a notice of appeal that alleges errors of law on the part of the trial judge, and on we'll go, but we'll find out soon enough one way or the other. What will personal cultivation look like? So assuming that is where we're going to end up, obviously at this point we don't know exactly what it's going to look like. It could be something that's very similar to the personal cultivation rights under the MMAR, or we could end up with something that looks very different. The government's going to have to think about a number of issues of how they're going to regulate personal cultivation. Production limits is obviously an issue. Under the MMAR, the limit on any particular production license was referenced in terms of number of plants only. It assumed a yield of 30 grams per plant, but the judge in this case readily admitted that that's not a very good measure because the ability to, the yield that can be obtained from a plant really varies wildly. And in fact, I think what the judge said was with the right lighting and physical space, an individual could obtain the same yield from 6 plants as from 600. So I expect that we will see production limits that speak not only to the number of plants, but probably also a permitted yield. We're going to have to look at possession limits. I expect, as a result of the decision in this case, that we will still see the same possession limits that exist in the MMPR to remain, because that was essentially blessed by the judge in this case anyway. We're going to have to look at permissible limits, locations for production. Under the MMAR, outdoor growing was permissible. So will the government replicate that and allow outdoor gardens as well? We will have to see. Will a medical document be required? It's a little bit different how you get authorized under the MMPR than the MAR. Still required the participation of a doctor, but essentially it was the government who was blessing and granting your license to possess and produce. Under the MMPR, you are getting a medical document which is basically a prescription from a physician. So this is already a major issue in the MMPR world, which is many physicians are reluctant or just frankly not willing to grant medical documents for cannabis. And so I wonder if medical documents, I assume they will also be required for personal cultivation, is how will doctors feel about that? If that's the only thing that's required in order to personally cultivate your own medical cannabis, and is a physician going to be nervous about the fact they're now essentially authorizing a grow-op? So I think that's a real issue that needs to be considered. Another one that I think is going to be interesting is whether the government will allow designated growers, as was the case in the MMAR, because there are certainly situations where, for a number of reasons, someone is not able to grow their own medical cannabis and they'd like to delegate someone else to do that for them. The question in my mind is, will licensed producers be the designated growers? If you can't grow yourself, will you be forced to buy from a licensed producer, or will you still be permitted to allow someone else to grow for you? On the issue of diversion, will multiple patients or designated growers be permitted to grow at the same address? So under the MMAR, you could have up to 4 production licenses name the same address as being the site for the growing. So when you couple that with the kind of skewed production limits due to the number of plants, you had some pretty major grow-ups going on, and we know that that's been one of the main sources of diversion under the MMAR that was government concern, and is how really dispensaries are sourcing their supply right now. So will we see the government try to restrict that further in order to minimize any diversion? And will we see any additional restrictions at a municipal level? We've seen a lot of municipalities across the country pass new zoning bylaws to deal specifically with the MMPR. And so, I will be interested to see if they feel further zoning restrictions are going to be applicable at the municipal level or warranted to constrain personal cultivation. Since the decision was released, a number of licensed producers have made statements to the effect that they support the decision. They support better access to medical cannabis for patients, and they don't believe that the decision will have a detrimental effect on their business. Of course they're going to say that, but I believe for now that is in fact the case. I don't think the personal cultivation right in and of itself is going to have much of an impact upon the licensed producers. I think those people that want to grow their own medical cannabis are growing their own medical cannabis and are going to continue to do so, and they were never going to be MMPR patients. And I think the lawyers for the plaintiffs have readily admitted that those who want to grow their own medical cannabis probably constitute a pretty small percentage of the overall number of medical cannabis patients. But I think the bigger challenges that the licensed producers are facing right now are dispensaries and doctors. So as you know, there's been a real proliferation in the number of dispensaries across the country in the last 1 or 2 years, and that for sure has redirected people who would otherwise have been medical or MMPR patients to a dispensary point of sale instead. And as I said before, there's an issue with doctors still being uncomfortable with being the gatekeepers of access to medical cannabis. So I think the bigger question for licensed producers is whether this decision is going to precipitate other changes to the MMPR which would have a more significant impact upon them. So and potentially a very positive impact upon them. So the main example I see of that is an ability to sell through the MMPR at retail. There's lots of different models that people have been talking about of how that could happen. We've seen Shoppers Drug Mart and Rexall in the news lately confirming that they've looked into, they're considering being licensed under the MMPR to sell medical cannabis or oil. You've obviously got hundreds of dispensaries across the country who are, indicating that they are ready, willing, and able to be a point of retail sale for medical marijuana, and many of them indicating they would be willing to come within a licensed regime for dispensaries should the federal government create one. There's obviously still an opportunity for the licensed producers themselves to have a retail point of sale. So I will be very interested to see, and I'm sure the LPs will as well, whether the federal government is going to introduce some type of retail sale to one of those points of sale, or maybe some combination of them. Who knows? A centralized registration system for the MMPR is something I believe the government should be taking a good look at, because I believe this is part of the access problem that was at the heart of this case, and in particular the availability of a patient's strain of choice, because right now your medical document is registered with one licensed producer. You would presumably register with a licensed producer who has and availability of your strain of choice, but there's no guarantee that when you go to purchase medicine next month that they're not going to have run out of it, or they're not going to have simply decided not to grow that strain any longer. So you were essentially taking a risk and a gamble that that strain would continue to be available throughout the duration of your medical document, because if it wasn't, it was quite cumbersome. You have to go back. It is quite cumbersome. You have to go back to your doctor, obtain a new medical document, which can sometimes involve payment of hundreds of dollars of fees, and then go through the registration process all over again with another licensed producer. So a centralized registration system would make it simple for patients to access the aggregate supply of cannabis from all licensed producers, and I think that would be a very good thing for patients. And another thing that I'm hoping the government's going to take a look at is relaxing the security requirements for LPs. David Hyde, who's a security consultant that does quite a bit of work in the MMPR area, once, and I respect his opinion very much, once said to me that, you know, it's the security, in some respects, the security requirements imposed upon licensed producers is greater than what you'd find at a nuclear facility, which you know, is kind of hard to rationalize. And you know, coupled with the fact that then the only source of delivery for MMPR product right now is the mail, so it's a little bit hard to justify the you know, the vaults and the high definition security cameras and all of the other very strict security when it's then going into the mail. And it's going to be even harder to justify if you could conceivably have a patient living a few hundred meters away from the licensed producer's site, growing it in their garage or possibly even their backyard. So I think that's something the government needs to take a good hard look at. The fact is, if the security requirements were relaxed to a reasonable level that still imposed a reasonable amount of public safety, what we would see is, first of all, it would be removal of this barrier of entry, because it is such that it's become a barrier of entry for licensed producers, and I think it would also ultimately result in lower cost product being made available to patients. So I think it would be a good thing all around. I think that's basically it for what I wanted to present on. I see there's a number of questions that have come in, so I'll take a look at those. But I will just say, if I'm not able to get to your question today, or you know, just answer it off the cuff at this point, you can feel free to contact me directly. I put my email address on the slide, and feel free to follow me on Twitter as well. My Twitter feed is exclusively dedicated to cannabis issues. So I will just take a quick look here and see if there's any questions that I'm able to answer for you at this point. Does the MMAR storage limit stand? Yes, it would stand, because if you fall within the scope of the injunction, then your license remains intact, as is, subject only to the possession limit. So in all other respects, the license remains in full force and effect. Okay, and the other question was, what if the patient holds a valid MMAR production license but can't grow at that address and has had to sign up with an LP for access? Is that patient now able to have a personal garden at a new site? No, you're not. And I've heard comments from John Conroy already that that is one of the issues he intends to communicate with the government on, and hopefully be able to consensually obtain some immediate relief for people that fall within that and other categories of non-compliance with the injunction terms. And if, I think he's indicated that if he's not able to get that kind of relief consensually with the government, then he's prepared to go back to court again to try to argue for it. So I think we'll have to wait and see how things play out over the upcoming weeks and months to see what's going to happen with those issues. I do see a number of questions asking about what the new restrictions or requirements for personal cultivation will include. And, you know, as I've already said, I don't know. It's really going to be up to the government to decide how they want to craft it, if they're prepared to just comply with the order and do so. And I'm really not sure what to expect at this point. Obviously, we've got, you know, interplay of additional considerations. A new government who said it is pro-legalization and regulation of cannabis, who's knee-deep in, you know, creating a task force that's going to look at how to do that. So, you know, I think the government's going to have to kind of carefully work out how all of that is going to come together in a seamless and consistent way. So I don't know at this point exactly what cultivation is going to look like. I don't know if it's going to be medical only or if it will be ultimately opened up for the recreational market as well. I mean, everything is up for grabs at this point. Another question was, will new evidence be admissible upon appeal if there is an appeal? Generally speaking, no. You can't admit new evidence on appeal. I think there are certain exceptions to that rule, but it's very difficult to convince a court of appeal that it should look at any evidence that wasn't already before the trial judge. Does this recent court injunction still allow all patients using marijuana medically to grow their own marijuana across all provinces or only in BC? It's across the board, and it's not really by virtue of the order itself, because as I said, technically the order only applies to the 4 plaintiffs, but Health Canada has already committed itself to a position that anybody that falls within the date stipulations of the injunction order, their license will be deemed to continue as well, and it's not restricted to just BC, it's anywhere in Canada. This is an interesting question. Is there any chance the government will set up a new MMPR system allowing LPs to also house designated growers or individual patients? You know, that's a very interesting question. It's one I'd actually been thinking about, because it would certainly address the issue of consistency and availability of specific strains. So would there be an opportunity to reduce the production costs for individuals by letting them kind of shelter within a site that's already licensed and secure, but also give them the flexibility to grow what they want to grow? And I think that's an interesting thought. And the answer is I don't know if that will form part of it, but it's definitely, I don't know if any licensed producers would be interested in permitting that in their site, but that kind of concept of collective growing, whether it's in a licensed site or otherwise, I mean, that's going to be a really interesting part to see what the government does with that. So I think that basically covers the questions that have been posed. I don't know if anyone else has any other questions following the presentation. As I said, feel free to just contact me directly. And thank you very much for joining us today.
Thank you, Trina, very much. It's been an interesting presentation. I think we've covered most of the options and the what's going to happen now questions. We want to thank Trina of Brazos Heller for offering her expertise to us on this subject. The webinar will be available online tomorrow on demand, and there'll be full video on YouTube, as well as slides which will be on our SlideShare account. Links to both will be sent out to everybody who's registered by tomorrow afternoon. We all hope that you've enjoyed this session, and feel free to make proposals of sessions that you are interested in hearing on any concerns to cancer patients and survivors. Our next webinar right now is set for March 31st. There may be one in between, in which case you'll all be notified. March 31st, we're going to have the body-mind-spirit connection, making a difference on the cancer journey. And we'll have more details about the presenter later on. So thank you, Trina. Thank you all for attending, and have a lovely rest of the afternoon, everyone.